Imagine it is like 4:55 p.m. on a Friday. You are totally exhausted, the office is emptying out, and a panicked lawyer from another firm calls your front desk.
Oh, the classic Friday afternoon nightmare.
Right. It
Yeah.
always happens then. So they are frantic about a property transaction and ask where the signed contracts are. Your receptionist is just, trying to be helpful and get them off the phone so everyone can finally go home.
Yeah, completely understandable.
So the receptionist says, "Don't worry, we'll email the documents before we leave today." They hang up, get distracted by, I don't know, a delivery or something, and completely forget to send the email.
Ouch.
Yeah. According to the strict rules of the legal profession, that casual 5-second conversation by a non-lawyer may have just committed a catastrophic ethical breach on your behalf.
It really is wild, but yeah, that one passing comment can absolutely trigger a formal regulatory investigation.
Which is terrifying.
It is. It is one of the most terrifying hidden traps in the legal profession, actually. And I think it perfectly illustrates how wildly different legal ethics are from our everyday understanding of just, right and wrong.
Because we kind of expect the law to be like engineering, right?
Right, like mathematical precision, visible rules, clear binary outcomes.
Yeah.
But professional conduct is just an entirely different ecosystem.
Well, welcome to today's deep dive. Whether you are currently buried in textbooks studying for your SQE 1, that is the massive solicitor's qualifying examination you have to pass to practice law in the UK, or you are just an insanely curious mind, fascinated by the hidden psychology and rules of the legal profession, we have an incredible journey ahead today.
We really do.
We are unpacking the 7 SRA Principles. Those are the foundational rules set by the Solicitors Regulation Authority. But we aren't just going to sit here reciting a dry list.
No, definitely not.
We are exploring the actual mechanics of how these ethics dictate behavior in the real world. Because ethics in law is not just like a polite suggestion. It is the very structural integrity of the entire justice system.
It's the foundational architecture, really. And, looking through the source materials, analyzing these 7 principles, a really fascinating pattern emerges right away.
Yeah, I noticed that too.
Every single ethics question, every complicated scenario you could possibly face in a law firm, it fundamentally boils down to one central stress test.
And what is that?
Can the public trust solicitors?
Ah, right.
Yeah, if you look at any situation, personal or professional, and the answer to that question is no, or even maybe not, the whole system starts to collapse. That concept of absolute, unwavering public trust is the lens through which every single rule we discuss today has to be viewed.
Okay, let's unpack this, starting with what it actually means to carry that burden of trust day in and day out. This brings us to the first 2 principles.
Right, principles 1 and 2.
So, Principle 1 mandates that a solicitor must uphold the rule of law and the proper administration of justice. And then Principle 2 requires maintaining public trust and confidence in the solicitor's profession. Now, upholding the rule of law sounds incredibly grand, but the sources clarify a very specific mechanism here.
They do, yeah.
Solicitors are officers of the court. That means their duty to the judge actually supersedes everything else. You can't knowingly mislead a court, and you can't help a client abuse a legal process.
Exactly. Because the judge has to take your word as absolute fact. I mean, the justice system would just grind to a halt if a judge had to independently verify every single statement or document presented by a lawyer.
They'd never get through a single trial.
Exactly. The court relies on the fact that the solicitor has already filtered out the lies. That is what being an officer of the court means in practice. You are essentially a trusted node in the network of justice.
Which makes Principle 2, maintaining public trust, so critical. But how far does that actually go? I mean, having a legal license seems less like a 9-to-5 badge you scan at the office door and more like, I don't know, a high-level security clearance.
That's a really good way to put it.
Is being a solicitor like being a superhero where you can never really take off the cape? Like, the government doesn't stop caring about your trustworthiness just because it's the weekend?
No, they certainly do not.
So what happens if a solicitor makes a terrible mistake in their purely private life? Say they're at a barbecue on a Saturday night, they have way too much to drink, and they get a DUI on the way home. It has absolutely zero connection to their desk job. Does the SRA actually still care?
Oh, the SRA cares immensely. The regulator, they do not stop scrutinizing your conduct just because you've logged out of your firm's portal for the weekend.
Yeah.
The 5 p.m. rule is a myth.
Wow, so your private life is fair game. Totally. And what's fascinating here is the psychological mechanics of public perception. The justice system requires the everyday citizen to believe that the individuals operating it are fundamentally reliable and law-abiding.
Right.
So if a member of the public hears the word solicitor, the immediate subconscious association must be one of integrity. If a solicitor commits a criminal offense in their private life, whether it's a drunk driving conviction, a minor fraud, or like a physical altercation, it shatters that association.
Because the public looks at that weekend behavior and thinks, well, if they are perfectly willing to break the law when they think no one is looking on a Saturday night, how on earth can I trust them with my life savings on a Monday morning?
Or my freedom. Exactly. It creates a massive ripple effect. The damage isn't localized to just that one individual's reputation. It degrades public confidence in the entire profession.
Which undermines everything. Right. If society stops trusting lawyers, they stop using the legal system to resolve disputes, and society itself just becomes less stable. This is a classic trap that catches out young, newly qualified lawyers every single year. And for anyone listening who is studying for the SQE, this is a major exam alert.
Oh, good to know. Pay attention to this part.
Yeah, students assume their private life is a walled garden. But a criminal conviction in a solicitor's private life is highly likely to breach Principle 2, and the consequences can be absolutely devastating. We're talking about being struck off the roll of solicitors entirely.
Wait, really?
Yes, your career just over because of a Saturday night decision.
That is a phenomenal amount of weight to carry. You are entirely responsible for your own actions 204/7. But, that realization brings up a much more insidious threat, I think.
How so?
Well, if your career relies on your personal accountability, what happens when the pressure to break that trust isn't coming from your own bad decisions, but from the person who actually signs your paychecks?
Yes. You are hitting on the core tension of Principle 3, which is all about independence.
Right.
A solicitor's legal advice must be uncompromised. It has to be completely your own professional judgment, entirely free from external pressures.
Yeah.
You cannot allow your advice to be bent or warped by your employer, your client, your family, or your friends.
Okay, I want to push back on this a little bit because that sounds beautiful in an ethics textbook, but let's drop this into the real world for a second.
Sure, let's do it.
Let's say you are an in-house solicitor. You aren't working at some massive law firm with 50 senior partners to back you up and protect you. You are the sole legal counsel working directly for a corporation.
Okay, high-pressure environment.
Exactly. You are sitting in a boardroom. The CEO and the CFO are just glaring at you across the table. They explicitly demand that you hide a crucial document from regulators just to save the company's stock price. I mean, they determine if you get a bonus. They determine if you can pay your mortgage next month. Can't you just explain to the SRA later, hey, I had no choice, I was just following orders?
I get why people think that, but no. The following orders defense is a complete fallacy in legal ethics. It is strictly prohibited.
Yeah.
None. If a CEO demands you do something that breaches SRA rules, your professional obligations to the regulator will always trump your boss's demands. And this raises an important question about who an in-house solicitor actually serves.
Right, because it feels like they serve the company.
It does, and while the corporation pays the salary, the solicitor's primary allegiance is always to the profession and the rule of law. You are a solicitor first and a corporate employee second.
That has got to be incredibly stressful, though. You essentially have to look the person who controls your livelihood in the eye and say no. You are risking your entire financial stability just to protect this abstract concept of the profession's integrity.
The pressure in those boardrooms is immense. There's no denying that. The regulator knows that solicitors face intense coercion to bend the rules to facilitate business. But by making independence a mandatory, non-negotiable principle, the SRA is actually providing solicitors with a really powerful shield.
A shield? How so?
Well, instead of having to argue with a CEO about whether a decision is good or bad for the company, the solicitor can simply say, look, it is not that I don't want to help the company achieve its goals. It is that my regulator legally forbids me from taking this action, and if I do it, I will lose my license to practice entirely.
Ah, I see.
It removes the ambiguity,
Yeah.
It takes the personal target right off the solicitor's back.
Wow, that completely flips the perspective. The rule isn't just a burden, it is professional armor.
Exactly.
So, okay, you've successfully stood up to your CEO, you've maintained your independence, and miraculously, you kept your job. But the next day, you are sitting at a negotiation table, and the pressure isn't coming from your boss anymore. It's coming from your own desire to win the negotiation for your client.
A very different kind of pressure.
Yeah, and this is where we hit what the sources highlight as the most confusing distinction in all of legal professional conduct. We're looking at the nuance of deception. Principle 4 is honesty, and Principle 5 is integrity.
Yeah, these two concepts trip up almost everyone. And it makes sense why, because in everyday conversation, we use honesty and integrity interchangeably, don't we?
Yeah, they basically just mean being a good person.
Right. We treat them as synonyms. But in the architecture of legal ethics, they are completely distinct metrics with very different boundaries.
Here's where it gets really interesting, because the sources provide a brilliant little memory trick to separate the two. So, Principle 4, honesty, is basically about the literal truth.
Right. Don't lie.
Exactly. Don't lie, don't mislead, don't draft a document you know is false. But Principle 5, integrity, is fundamentally about fairness. The ultimate metric for integrity is, would a respectable solicitor think this behavior was appropriate?
That's the golden question.
Right. I was thinking about this distinction, and it made me imagine a scenario based on the notes about dealing with unrepresented parties. Let's say you are a seasoned solicitor representing a massive tech conglomerate, and you are sitting across the table from a small business owner who just cannot afford a lawyer. They are completely unrepresented.
A classic David and Goliath scenario, where Goliath has a massive informational advantage.
Exactly. And you slide a highly complex, dense, 50-page legal contract across the table. Now, you know for a fact that this small business owner does not understand the dense legal jargon. And you specifically know that buried on page 42, there is a landmine of a clause that heavily disadvantages them and hugely benefits your tech client.
Okay, setting the trap.
Right. Now, when you hand them the contract, you don't lie. You don't say, oh, this document is extremely generous to you. You just hand it over and wait for them to sign it. Technically, you haven't made a false statement, right?
You have not made a false statement, which means you have not technically breached Principle 4. You have preserved your honesty.
So I'm in the clear.
No, because this is exactly where Principle 5 steps in. You are deliberately weaponizing their lack of legal knowledge to score an unfair victory for your client. You are exploiting their ignorance.
Wow.
So if we ask the metric question, would a respectable solicitor think it is appropriate to trap a layman with dense legalese? The answer is a resounding no. You haven't lied, but you have entirely failed to act with integrity.
That is a subtle but monumental distinction. You can tell the literal truth and still be acting completely unethically because you are not doing the right thing. You are not upholding the moral standards of the profession.
Exactly.
That memory trick really is perfect. Honesty is about literal truth. Integrity is about fairness.
And integrity acts as a much broader net. It is designed to catch all those predatory, sharp-elbowed behaviors that might technically scrape past the strict rules of honesty, but would still leave a toxic stain on the profession's reputation. It forces a solicitor to look beyond the letter of the rule and really consider the spirit of fair play.
So, if integrity requires treating people with fairness and high professional standards, how does that philosophy apply to the wildly diverse range of clients and colleagues a solicitor interacts with every single day? This brings us to Principle 6 and Principle 7. And specifically, what happens when you hit a wall and these mandatory rules actually collide with each other?
Right. So Principle 6 is the mandate to encourage equality, diversity, and inclusion, often referred to as EDI. It requires solicitors to treat clients, colleagues, and third parties fairly, strictly prohibiting discrimination based on protected characteristics like race, sex, disability, religion, or age.
And the sources are very explicit about how this intersects with a solicitor's own personal worldview. Like, a solicitor cannot refuse to represent a client simply because they personally disagree with the client's political opinions or lifestyle.
No, they absolutely cannot.
Your personal beliefs have to stay at home. You are there to provide access to the law, not to act as some sort of moral gatekeeper.
That's right. The legal system functions as a public utility. It only works if everyone has access to it. If solicitors start picking and choosing who gets legal representation based on their own personal political leanings, well, the public quickly loses trust in the impartiality of the system.
The trust thing again.
Always. Access to justice requires professionals to compartmentalize their personal biases.
The sources also dig into the concept of reasonable adjustments under Principle 6. So if you have disabled clients or disabled employees, a law firm is required to provide accessible formats, perhaps sign language interpreters, or wheelchair-accessible meeting rooms. But there is a massive financial caveat here that honestly feels like a bit of a trap for a small business owner trying to manage their overhead.
Yes, the law requires these reasonable adjustments so that disabled individuals are not placed at a substantial disadvantage when trying to access legal services. But the critical mechanism behind this rule is who bears the financial burden.
And it's not the client.
Definitely not. A solicitor absolutely cannot pass the cost of those adjustments on to the disabled client or employee. You cannot tell a client, sure, I am happy to hire an interpreter for our consultation, but I am adding a £200 surcharge to your final invoice.
Which makes sense on a human level, but why is that so strictly enforced in the ethics code?
Well, think about it. If firms were allowed to pass on those costs, it would effectively create a hidden disability tax on the justice system.
Oh, a disability tax.
Yeah. It would financially penalize disabled individuals simply for asserting their legal rights, basically pricing them entirely out of the system. Therefore, the firm must absorb that cost as a baseline expense of doing business equitably in a modern society.
That disability tax framing makes it instantly clear why the rule exists. It is all about unhindered access. But let's look at the client side of the equation with Principle 7. This one mandates that a solicitor must act in each client's best interests. And the emphasis in the sources is heavily on the word each.
Yes, very heavily.
You cannot sideline a low-paying client or a pro bono case just because you landed a massive, lucrative corporate account. Everyone on your desk gets competent, dedicated representation.
It demands an unwavering standard of care, regardless of the client's invoice size.
So here is a direct question, and I know this is the exact scenario everyone studying the law dreads. What happens when these absolute mandatory principles fight each other?
The dreaded conflict of duties.
Yes. Let's say I am a solicitor. I have a mandatory duty to uphold the rule of law and the administration of justice, that is Principle 1. But I also have a mandatory duty to act in my client's best interests, that is Principle 7.
Okay, set on the stage.
If my client desperately wants me to take a specific action that will definitely help them win their case, which is clearly in their best interest, but doing so requires me to slightly mislead the court or bend the rules of justice, well, those two rules are at war. Who wins?
If we connect this to the bigger picture, the resolution to that conflict reveals the entire underlying philosophy of the legal profession. When principles conflict, the rule is always this: the principle that protects the wider public interest takes absolute priority.
Every time.
Every single time.
So the wider public interest is the ultimate trump card.
It is. In your scenario, Principle 1 wins decisively. Upholding the rule of law protects the structural integrity of the justice system itself. Acting in a client's best interest only protects one single individual.
So it's macro versus micro.
Exactly. Protecting the ecosystem is always more important than protecting one organism within it. If the system collapses because solicitors start lying to judges to help their individual clients win, then the concept of a fair trial ceases to exist and no one gets justice anymore. The system always over the individual.
That is incredibly clear. It is almost a mathematical formula when you lay it out like that. But while the wider public interest wins in a theoretical debate, I want to talk about how these ethical landmines get triggered in completely mundane, everyday office interactions.
Oh, this is where it gets scary.
It really does. This brings us back to where we started today, the daily danger zones. We've already touched on the danger of negotiating with unrepresented parties. Like, you can negotiate with them, but you cannot exploit their ignorance without breaching integrity.
Right.
But the other major danger zone in the source is, this is the one that genuinely blew my mind: undertakings. So what does this all mean? The sources define an undertaking as any statement made by a solicitor or on behalf of a solicitor that someone else is entitled to rely on.
And this brings us right back to our Friday afternoon scenario with the receptionist.
Yes.
The key operating word in the definition of an undertaking is reliance. It is a promise that causes the other party to alter their behavior or expectations based on your word. It doesn't have to be formally drafted on heavy cardstock.
It doesn't have to be signed in blood by a senior partner.
No, it doesn't even have to be in writing.
Which is wild to me. A passing verbal comment binds the firm.
Completely. When that receptionist said, "We will email the documents today," the lawyer on the other end of the phone relied on that promise. They told their own client the documents were coming. They stopped searching for alternative solutions. They closed their file for the weekend.
Because they trusted you.
Yes. And because they relied on a promise made by your firm's staff. If your firm fails to deliver those documents that day, there is an incredibly strong argument that an undertaking has been breached. And let me tell you, breaching an undertaking is viewed by the regulator as a catastrophic ethical failure.
Because it goes right back to the thesis, doesn't it? Can the public trust solicitors? If your firm doesn't keep its promises, the trust is broken.
Exactly.
Hmm.
This is the exact trap that catches out young professionals constantly. Whenever you encounter a scenario in practice where someone is relying on a promise made by anyone in a law firm, whether it was declared by a senior partner in a meeting or just casually mentioned by an intern in an elevator, you have to pause and ask, could this amount to an undertaking?
It really makes you realize why law firms are so obsessive about their internal training and communication policies. Like, you can't just have people saying things.
No, every word counts.
Well, let's take a breath and briefly recap the journey we've just been on. We started with the core mission. Absolute public trust is the foundation of the 7 SRA Principles. If the public cannot trust you, the system fails. We learned that the security clearance of being a solicitor never turns off. Your private life, including that Saturday night barbecue, is constantly under scrutiny to protect the profession's reputation.
And we dissected the crucial difference between honesty, which is merely telling the literal truth, and integrity, which requires actively doing the right, fair thing, especially when dealing with vulnerable parties.
Right.
We established that independence provides a vital shield against corporate pressure, and that the cost of equality and reasonable adjustments cannot be passed on as a hidden tax to disabled clients.
And crucially, we learned the ultimate formula for resolving ethical gridlock. When mandatory principles collide, the wider public interest protecting the justice system itself always defeats the interests of any single client.
For anyone listening who is preparing to enter this profession, the key takeaway is to approach these concepts not as a list to be memorized, but as a framework for critical thinking. Understanding the hidden mechanisms behind the rules, the why, rather than just the what is the only way to successfully navigate the remarkably muddy waters of professional practice.
It is about seeing the matrix behind the daily grind. Which leads me to a final thought I want to leave you with. Think back to that undertaking example. If a casual passing promise by a busy receptionist trying to get off the phone on a Friday afternoon can carry the full, devastating weight of a professional ethical breach, how many everyday, totally mundane conversations happening in corporate offices right now are actually invisible ethical landmines, just waiting for someone to step on them? Keep an eye where you step. We'll catch you on the next deep dive.